哇，咁型嘅呢家嘢，第一次玩咁大嘅。 可以咁講。
係嘛？
冇一定嘅，
冇一定。
有時睇你自己嘅 style。呢個係 rugby 嘅國家啦，即係呢幾樣嘢係要你都要俾到老師睇到。咁但係唔一定話每一個 issue 你獨立都做一次。所以康定係話中意我一個，我照所有嘢混合都得㗎。我睇個 paragraph，我話我依個 case 我睇到有3個 issue 都得㗎。咁呢個 paragraph 講就3個，跟住第二個 paragraph 你咪照落同解一齊參考都得。呢係你個 writing style， 就冇一定嘅。
OK， 即係冇
一定嘅。
好，明白 ，thank you。
Before we start the class, I want to show you a video, with only a few minutes, from our Chief Justice, Mr. Ma, concerning legal writing. Right? It's only a few minutes. So I think that will be helpful for you during the assignment. Right? So I play a video to you. It lasts around 5 minutes only. All right? Yeah, of course. Later when you back home, you can watch the whole thing. So I'm only paying the part which I think will be related to our assignment, right? When you back home, you can watch the whole thing. So all of you know him, right? CJ.
The main thing to bear in mind is starting point in approaching a legal question is to understand what the objective is, to understand the person to whom the legal essay or the legal opinion is directed. Now, it usually, in terms of judgment, it is to the parties, it is to the world in general. In terms of a legal opinion, which I think is probably the main part of legal writing, it would be the client, if you're a barrister, to the solicitor. Now, with that in mind, you then put yourself, as the first approach to legal writing, put yourself in the position of the recipient of the advice and ask yourself, what is it that the person is after? Usually it's an answer. That will then give you an idea as to how to approach your writing. And the first point here is to have a structure. In terms of a legal problem, answering a question in a legal problem, the formula should be quite simple, really. You look to see what the problem is.
It's something I already told you, right?
You then analyze
Structure,
what the facts are in any particular case. You identify what the law is, and then you simply answer the question. Now, it sounds simple, and probably many people will think it's obvious, but you will be quite surprised at how often people don't follow this simple formula. This is another way of asking the question of what not to do, because the formula is simple enough. Identify what the problem is, identify the facts, find out what the law is, then apply the law to the facts. What a lot of people do is they get distracted by a number of things. Sometimes they can't help it, and they go off on a tangent of their own, they go on a frolic of their own, and they tend, I think this is the worst thing one sees in a piece of legal writing, they tend to show off their knowledge of the law instead of addressing
Show off their knowledge means they try to write everything they learned from class. But actually it's not related to the question, right? So you have to be careful. Listen to Mr. Mark. So I just learned from him, right? I learned from him.
I think the two easiest examples to draw on would be a legal opinion and a judgment. Let's start with a legal opinion. You are usually addressing this to a client who wants to know an answer to a legal problem. That client wants to know, apart from the answer, your reasons
when you back home, you
for
can
the answer. Now,
watch the whole thing, right? But the most important thing we learned from Mr. Ma, number one, the structure, all right? Structure. So structure is always number one. And so you have to identify issues. The first thing you do, you have to explain the law, analysis, then finally come up with a conclusion or suggestions. Well, there's something I learned from Mr. Ma, right? So the IRAC or the ILAC is not something invented by Edwards. I learned from the senior lawyers and from the judge, from CJ, right? So that way is very effective in resolving legal problems. The second thing, don't show off. What I mean by showing off, you try to write everything you learn from class. You try to copy everything from the lecture notes and from the textbook. Because unlike the exam, right? Unlike the exam, in examination you only have 2 hours, so you don't have time to write the rubbish. But when you are doing the assignment, you have a whole week or whole month to do it. So some students, they try to show off, it means everything, right? They try to write down everything they learned from class without focusing on the right issues. And that will be a wrong approach, right? So bear in mind, when you back home, you can watch the whole thing. Actually, there's a whole series from legal writing, advocacy, the rule of law, many interesting topics. So you can search legal writing, CJ Mr. Ma, all right? Also, some students asked me to recommend a textbook. Well, as I told you already, that's not necessary. Say, for the exam purpose, right? For exam purpose, my lecture notes will be more than enough. I told you already, right? My lecture notes will be more than enough. You only have 2 hours. And for the assignment, apart from my lecture notes, you can also read the course manual, right? Course manual and the lecture notes and what you learned in the class will be more than enough. Because, I mean, the assignment is not to test your research. It's not to test your research skills, but to solve the problem, right? Problem-based. So I don't think you need a lot of information. But for a reason, you really like to have a textbook. For example, there are some topics you want to know more, right? More than what you learned in the classroom. So this one will be good. This one, right? This one. Law of Companies in Hong Kong, 3rd edition. This book is quite good and updated, right? Relatively updated. Published on 12/1/19, I don't remember. 1819, I don't remember. Okay. The information is still up to date, right? If you really want to know more, you can take a look at this book. But remember, not necessary, right? Not necessary. So this book intended for students studying in LB and JD, not at the diploma level, right? So not at your level. But if you really want to know more in certain topics, for example, maybe some of you were in the finance industry, so some of you were as a company secretary, or you were in a listed company, so you want to know more in a particular area, so you can take a look at this book, and also this one. And also this one. You can borrow from library, so don't buy it. Very expensive. This one, $3,000. Right. The previous one, $2,800. So save your money for your Christmas party or buffet, right? So don't waste time to buy a legal textbook. It's very expensive. I don't think you have to buy it, right? Unless you are a lawyer. So if you really want to take a look, you can borrow from Hong Kong Library. So you get the library card, all right? So if you really have time, you really want to know more, and you can take a look, all right? Okay, anything else? Oh, this one, who's this guy?
So handsome.
Yeah, I know. I agree with you. Right. I agree with you. 中國嚟嘅咁靚仔。Okay, there's nothing to do with your assignment, right? Some more tips regarding the assignment, right? Little bit more for you. When you're doing the assignment, the two shareholders, Janice and Patrick, right? Jensen and Patrick. So each of them own 50% shares of the company, right?
Yes.
I think that that's an issue here, and you have to discuss. So I intentionally set the holding structure to be 50-50. So it means something, and I think you have to discuss, all right? You have to. Number one. Number two, whenever you think about derived actions or unfair prejudice application, bear in mind, so you can only initiate the legal proceeding, derived action, right? And unfair prejudice application as the last resort. What I mean by last resort? You have to persuade the court that that's the only way that I can solve the problem, unless I can get the court order, right? Because if there are alternative remedies still available, the court will be very reluctant to grant an order regarding derived actions or unfair prejudice application. So you have to be careful whenever you think about anything in lecture 8. Right? That's all. So any question, if you still want to know more about the assignment, so make sure that you talk to me before the end of class. Because today will be the last lecture, right? Not the last class, but the last lecture to teaching. Right? So you still have the last chance to ask questions related to the assignment, right? Okay. So let's start the class. So lecture 10. So any of you still remember what we learned at the very beginning regarding company law? That is lecture 3, as I remember, lecture 3. So what's the first thing we learned in lecture 3 regarding a company, corporate? So we have 3 different vehicles. So number 1, sole proprietor, number 2, partnership, and number 3, company, right? So what we learned at the very beginning, regarding a company, first thing, what's the first thing to learn? Oh, come on. A legal person. That's the second thing we learned. The Solomon case. You are right, the second thing, but the second thing, very important, Solomon case, Solomon principle. But what's the first thing we learned regarding a company? That's not Solomon principle. That's not Solomon case. Different types of company. Different types of company. Right, you're correct, right? But that's not my focus. The first thing we learned, I just want that answer only, right? Incorporation. Try to recall what we learned in lecture 3. Because we have to understand how to form a company. So, how to start your business as a sole proprietor? What you need to do to establish or to set up your sole proprietorship. Do you need to do anything in particular? No. No, you don't have to. Why? Because you are the business vehicle yourself, right? Do you remember the stylus, right? When we first use iPhone, we don't use the stylus. Because our fingers, the best stylus, the best inputting device. You already have it. And if you want to run your business as a sole proprietor, you don't have to do anything in particular because you are sole proprietor. And how about partnership? Partnership being formed under a contract, contractual relationship. So partnership only means a group of people. You don't have to do anything in particular in order to form a partnership. Of course, you need to be outside. But if you remember where you get to be outside, ILD. So be outside is all about what? Tax, right? It's a tax liability. Of course, you need to have it. You need to have it. But even without the be outside, you can still form a partnership. You can still run as a sole proprietor, which is perfectly legal. Right? Perfectly legal. But you will have problem with the IRD. But how about company? When you want to form a company, you have to incorporate a company. It means what?
Registration.
Registration, very good, right? You need to do registrations, compulsory. So unless you do the registrations and then get the certificate of incorporation, otherwise you don't have a company. Right? This is mandatory, compulsory. Okay, so if the first thing we need to learn is incorporation, so think of it. What's the last thing we learn about a company? So today is the last lecture.
Setting up.
Right, but what it means?
Death.
Yes, death. To kill a company, to terminate the life of a company. And there's something we call as winding up, right? So winding up. So remember, winding up, ing form, it means we refer to a process, right? So winding up is a process. So we are going to learn about a process. It means how to terminate the life of a company. We learn about how to form a company. We learn about how to establish a company, which is by incorporation, which is by registration, right? Filing form to CR. So the last thing to learn, how to kill a company. Right? And remember, winding up is a process. So we are going to learn about a process, right? How to do it. But before that, I also want you to learn so very important concept. Something we call deregistration. Deregistration. Because apart from winding up a company, so we have an alternative way to also to end the life of a company, which is simple, right? I mean, by comparing with winding up process, which is simple. Cost saving. It only takes a few days or weeks to do so. And there's something we call deregistrations. What I mean by deregistrations? Because according to section 750, a company can be deregistered by filing a form NDR1 to the company registry. So it means that you only need to file a form to the company registry, and then you can kill company. Very easy. Time saving, cost saving. Because later on you are going to learn about the winding up process. You know that it will be rather complicated. A lot of things you have to do. But the registration is very simple. Just file a form. But that will not be our focus in this lecture. Why? Because you want to deregister a company, you have to fulfill all the conditions here. For all the conditions listed out here. Remember, all of them, not either one. Right? Not either one, but all of them. So you have to fulfill all the requirements here. So we take a look for the preconditions listed out by section 750. So number one, when all the members agree. Number two, the company never commenced any operation or already ceased its operation for 3 months. No current legal proceeding, no immovable property, and without any objection from the ILD. Do you think that will be easy to fulfill all the preconditions here? Is it easy? How to answer a legal question? It depends. Right? Is it easy? Well, I'm serious. I'm serious, right? This answer is always applicable, but always true. Also always true. It depends why. Take a look here. The company never with any kind of operation. Never with any kind of real operation. It means this company, once being incorporated, never entered into any kind of transactions. No money in and out. So do you think that will be easy for a company with real operation? The answer is no. No, absolutely not. So not even being ceased for operation for 3 months. Think about a company with real operation. It means when you incorporate a company to run a business, a real business, buy or sell, right? Property developer, retail, wholesaler, anything. When you incorporate a company to run real business, then you have money in and out every single day. So how can you stop the operations for 3 months? Number one, all members agree. Is it easy? It depends. It depends on how many members in your company. Remember, 100%. And the maximum number, even for a private company, is 50. So sometimes it's not easy to have the agreement for all single members. Remember, the requirement is 100%. So even one member holding 1% of the shares rejected this proposal, and that's not allowed, and you cannot deregister a company, even with 1%, one member against it. So if your company, with your operation, you cannot deregister. If some of your members disagree, you cannot. No current legal proceeding. It means no one suing your company, and you are not suing anyone. That may not be very difficult. Right? It depends, but that may not be very difficult. Number 4, no immovable property means a piece of land or apartment or house. And again, it depends. Right? 3 or 4. But number 1 and 2 will be very difficult to achieve, especially for number 2. And the last one is without any objection from IRB, means that you already cleared your tax liability. And that will be quite difficult if your company has real operation. Because it takes quite a long time to clear up all your transactions. So it means that if you want to, so it means that, time out. So it means that if you want to deregister your company, oh yeah, still have the echo. Is it better?
Turn off. You should turn off.
Turn off already. Is it better by using this one? Better, right? Okay. It's better. Okay. So it means that will be very difficult if you want to deregister your company, unless you have a what? A dormant company. Do you remember dormant company? It means a company being incorporated and remain here without any transactions, without any operation, right? You just keep it here. In case if you want to have a company form, then you can use it immediately. So that's the purpose in setting up dormant company. So in real life, normally, only dormant company will be deregistered. Means a company never having any kind of operation, but remain here, established for some future purpose, but never being really used. For any company with real transactions, for any company with real business, the company will be very difficult to be deregistered. Okay? But anyway, I hope that at least you understand what I mean by deregistration. Then how about winding up? Remember, winding up is a process. Right? Winding up is a process intended to bring the life of a company to an end. It means you kill a company. We learn how to kill a company. And winding up is a process. Because once a company when the winding up process finished, a company will be dissolved. So winding up, remember, the ing form means it's ongoing. We refer to a process. Winding up is a process. Dissolved, once the company being terminated, we call the company being dissolved. So what we need to do in the winding process, you have the actual. So remember, winding up is a process, right? It's a process. So what's going to happen in the winding up process? A very important person you have to learn, and you have to remember, a liquidator. So what's going to happen in the winding up process? A liquidator will be appointed to take control of the company. Very important. Liquidator will be appointed. The whole thing, right? The whole process. What's going to happen in the winding up process? Someone being named as a liquidator, 清本人, will be appointed and then to take over the company. So this guy, the liquidator, normally is a CPA, sometimes is a solicitor. Normally is a CPA, because there will be a lot of calculation, right? Or a lot of accounting stuff that need to be handled by the liquidator. So a CPA will be a suitable person. So normally the liquidator will be sometimes a solicitor. Because some of the solicitors, they have accounting background. I also have an accounting background. So liquidator will be appointed to take control of the company. It means that the shareholders and the board of directors will no longer control the company, right? No longer control the company. Because normally, who control the company? Normally, who control the company? Come on. Come on, this last lecture. Huh? Right, the directors and the board of directors. Directors or the board of directors, it depends on how many directors in your company. If you have one director. If you have two or more directors, then the board of directors control the company. But once a liquidator being appointed, the directors are no longer in control of the company. So once a liquidator being appointed, he will handle what will be his primary duty as a liquidator to be appointed in this company. Think about winding up process. So what will be our concern in the winding up process? When you want to kill a company, when you want to terminate the life of a company, what will be our primary concern? What will be our main concern? Come on, think of it. So I'm always using an example like this. When a company is in a winding up process, it's like a big fish feeding, and then all the sharks smell the blood and want to have a bite. Right? I always use this example or metaphor. And some students complain to the program director. And that's cruelty to animals. Come on. That's the only example. Right? Just like a big fish feeding. Everyone smells the blood and they want to have a bite. What it means? You know that the company is dying. And then for all the stakeholders, do you know the term stakeholders? 持份者. It means everyone related to the company want to fight for their own interests. They want to have something. So what is the main duty of the liquidator? Is to handle all the debts and to distribute the remaining asset. Of course, based on the priority as stated in the company ordinance. It means to distribute the asset and then to satisfy all the claims. 拆骨, right? 還債. Distribute all the asset. You pay all of that. And that's the primary duty of the liquidator. And then company will be dissolved. When the whole thing finished, dissolved. So remember, winding up is a process. Finally, the company will be dissolved. And one thing you have to remember, the governing law. So why is it important? I hope that you still remember the deal regime of the company law. What I mean by deal regime? It means that we have two pieces of legislation. It means two pieces of company ordinance in Hong Kong. So we have the old one, we have the new one. The new one, Cap 622, came in force in 2014, and almost 95% of the company operation under the administration of the new company ordinance, of course. But there are two remaining areas. One is prospectus. Prospectus means a small booklet for a company if you want to raise funds from the public. And normally that's a listed company or a public company. Apart from that is winding up. So you have to be careful in lecture 10, in this lecture. So all the section numbers, right? All the section numbers I'm referring to the old company ordinance, Cap 32. So you have to be careful. So how to do the writing off? How to do the writing off? Company writing off. There are two approaches. Remember, there are two approaches. Number one, we look at this diagram here. Company writing off. Two different approaches. Number one, compulsory writing off. Right? Compulsory writing off. The first approach. Another approach, voluntary writing off. And voluntary writing off can be further divided with the subdivisions as creditors voluntary writing off, members voluntary writing off, and directors voluntary writing off. Just focus on the two approaches first. Compulsory writing off and voluntary writing off. I'm going to explain to you with all the details what I mean by all this stuff. So let's focus on the first one, compulsory writing off. Okay? The first one, compulsory writing off. And remember, compulsory writing off and voluntary writing off, two different approaches. But I can tell you that, right? I can tell you, I guarantee. So what you learned here, you change very soon. You change very soon. The government and the Department of Justice, they are working very hard to update our company ordinance. So one day, right, I think that will be not more than 2 years. The old company ordinance will be abolished at all. It means everything will be included in a new company ordinance. And we are going to amend the writing up process. Because the writing up process here, I can tell you, a little bit outdated. So that's the same approach used before the Second World War. And we are still using it. A little bit outdated. Right? And that will be changed very soon. But anyway, that's still the law. Right? At least up to today, still the law. And we have to understand. Right? But there will be changes, I guarantee. Right? I guarantee. Okay. So let's talk about compulsory writing off first. What I mean by compulsory writing off? What I mean by compulsory writing off? Namely, what I mean by compulsory first? What I mean by compulsory? So how you understand a word compulsory? What I mean by compulsory? It means what? It means compulsory. Compulsory means compulsory. I know. Compulsory means mandatory. Still the same. What I mean by compulsory? It means you have no choice. Compulsory, right? 強制, something like that. 強制. It means you don't have a choice. You have to do it. That's very misleading. That's very misleading. If I can name it, right, I would use some other name. If I can name it, I call it court writing off. I would call it court writing off. Because I don't really understand what I mean by compulsory writing off. So actually, compulsory writing off, it means court writing off. It's a court proceeding. Compulsory writing off, we look at the first paragraph, means that company to be ruled out by the court order. So, bear in mind, the first thing you learn here, compulsory writing off, actually means a court action. It means you are trying to make application to court and use the court authority and under the court order to terminate the life of a company. Court proceeding. You haven't yet learned about civil procedure. You're going to learn about it later when you study in the diploma or the advanced diploma. You're going to learn about it. Right? If you keep studying in Hong Kong space in this program. But civil procedure will be another area of law, very complicated. So we don't have to learn everything, but just bear in mind, compulsory writing off is a court proceeding. It means that you have to instruct a law firm and you have to instruct a lawyer in order to initiate compulsory winding up. Because it's a high court action. You already learned in the Hong Kong legal system. When you have a high court proceeding, you have to instruct what?
Barrister.
Barrister, right. So you have to instruct a barrister, not just a solicitor. So even a law firm cannot help you. But this is a high court proceeding. You need to have a barrister in order to initiate the compulsory winding up. So just remember, it's a court action. And you try to wipe a company. You try to kill a company with court order. Okay. Any of you still remember course of action? I explained to you before. Any of you still remember? Any of you still remember? Course of action. Someone get up. Any of you can recall what it means?
Reason.
The reason for what? Yes, you are correct.
Suing.
Yes, you are correct. Yes, very good answer. Remember that there's a very important concept in civil procedure. When you want to sue someone in court, I mean a civil action, not criminal. I mean civil actions. So if you want to sue anyone in court, you need to have a reason. You need to have a reason. That reason we call the cause of action. Right? Something like the reason for your action. And that cause of action must be something accepted by the court to be a valid reason to initiate a legal proceeding. Well, I'm not saying that you are going to win the case. That will be after the trial. You only know whether you can get a judgment, whether you will win or lose after the trial, right? But before that, before the whole thing started, you need to have the right course of action. Because if you don't have the right course of actions, even your initial proceeding will be struck off by the other party. It means you will never have a trial. The other parties, tell the court that you try to sue someone with the wrong reason, then you will not have any trial at all. You will strike off. It is the whole thing stopped, your application to the court. So the course of action is something really important. And sometimes even the lawyers, they make mistake, right? Especially the solicitors. When they are not really familiar in that particular area of law, they make mistake. So they file an application to the court, and later on learn that they have some conceptual error. It means that the reason is not actually valid in suing that person, right? They sue a person with the wrong reason. And that's that's what we call a course of action. Very important. If you want to initiate compulsory winding up, it's a court action, then you must have reason. You need to have reason. It means that you cannot just, because I want the court to help me. No, that's not a reason. You have to look at the law, because there are some reasons listed out, and only under this reason you can initiate compulsory winding up. So what are they? Number one, by special resolution, 75% of the matters. Do you mind I call someone to try to fix my microphone, right? Because the echo is very annoying, right? Sorry, I stop a few minutes, right? I try to call someone to fix it. 呢個係2014。電話係冇聲嘅，係假嘅呢個電話。你等我一陣，我出嚟揾你。Sorry, you wait a few minutes. Because it's really annoying. Yeah.
呢
試下講兩句嘢。我用譬如依個我又用過，依個又用過，依個都用過，依個冇用過，但係就全部都係啲 echo 好緊要。
而家開咗嘅。
係啊，你可以咁。
Hello，
你試下企喺嗱聽到啊，幫我開大聲啲咯。
喂，點樣？
開落去點樣？嗱，OK 啦，應該細啲喎。喂，你試下
細啲係咪？
係夠唔夠大？可能較大聲啲。
喂，hello，咁好啲啊，應該好啲啊，
應該好啲。
我試下行一行先啊。hello。
OK 喎。
hello，好似
OK，唔緊。如果你
可能開得太大。
係啦，如果你認為想細啲咧，再細啲撳下邊啦。想大啲就撳下邊。
可能係開得太大。
可能係喎。
Thank you，冇問題。Okay. Is it better, right? Is it better? Okay. So remember that, right? Remember that compulsory write-down is a court action. So we have to initiate a court action. It means we have to file application to the court, and under some reasons. So what are the reasons here? We have 6 different reasons. So number 1, when you pass a special resolution, it means when the members, they can pass a special resolution. Number 2, according to a particular requirement in the article, that the company shall be dissolved. So it means that if something stated in the article, and you are trying to make application to court based on that thing. Okay. I mean, for example, right? For example, when the company is not making money for 5 years, then the members, they have the right to apply to rob the company. If that's being stated in the article, then that will be the second reason. Do you get my point here? Right? To make application based on something stated in the article. Number 1, special resolution. It means that number 1 and 2 normally being available to members, right? To members. And for number 1, you don't need to have any reason at all. Only when you can pass special resolution, then you can initiate court winding up. And number 2, there must be something based on article. Then how about number 3 and 4? Number 3 and 4, I would say that some abnormal situation in the company. So think of it, for number 3, the company never had any business or being ceased with operation for over a year. It means the company suddenly stopped it without doing anything at all. And that's number 3. And number 4, the company has no member. Right? The company has no member. So for 3 and 4, we are referring to abnormal situation. Abnormal situation. Number 5, and that's the most important. Most important, I can tell you, you have to focus on it. We have to focus on it. When the company is unable to pay the debt, right? When the company is unable to pay the debt, and this one will be available for creditor. For example, you sign a contract with the company. You are a supplier, so you deliver the goods to the company. The company signs a contract with you. You already delivered the goods, but the company is not paying you. Not paying you according to the agreement. Not paying you according to the contract. Then the company is unable to pay the debt, and can be a reason that you make an application to court to wind up a company. So number 5, very important, and number 5 probably always being used by creditor. Number 6, just an equitable ground to rob the company. Something we already learned. Any of you still remember? Lecture 8. The last option, when you are suffering as a minority, what you can do. Lecture 8. Any of you remember what we learned in lecture 8? We learned in lecture 8 for derived actions and unfair prejudice application. And the last one is winding up under just and equitable ground for pseudo partnership. Any of you remember pseudo partnership? It means that you form the partnership. The Yonggi case. Do you remember that restaurant selling the roasted goose? Goose not that. Sandy, very famous for the roasted goose. So that company is a pseudo partnership. It means that company is a company. We are facing a company here, but that company is actually operated like a partnership. So we call pseudo partnership. So it means that the last one, right? The last one, when you are suffering, and when you are a minority, then probably you can apply to the court to wipe the company based on number 6. So it means that the 6 reasons here are actually available for different parties. You take a look. For the eligible parties, who can apply to court to wipe the company? So creditors, members, financial secretary, community registry, official receiver, and the SFC. So category 1 is creditor. And creditor normally concern number 5, regarding a debt of company. So they are related. Page 5 and page 6, they are related. Remember, creditors, right? Number 5 will be normally used by creditors. And then how about members? How about members? Which one? 1 and 2. So 1 and 2 normally will be used by members in file application to court. How about how about 3 to 6? I can sum it up with one single word. Class 1 creditor, class 2 member. 3 to 6 belong to a single class. I can sum it up with one word. Government, right, very good. Look at it. Financial secretary, community registry, official receiver, 破產管理處. The government department to handle all winding up and bankruptcy in Hong Kong. Official receiver. In the legal profession, they call the OR. The OR. OR means official receiver, 破產管理處. The last one, SFC. So you can sum it up with one single word, government. So normally government, they rely on 3 and 4. It means for abnormal situation. And for this one, the last one, I think very likely being used by members. Very likely. Because that's what we learned regarding the pseudo partnerships. But this one actually belongs to the discretion of the court. Right? Discretion. So even the members, I mean not just the member, even the creditors or government can also apply winding up order under category 6. But normally, number 6 also belongs to member. Okay? So remember, compulsory winding up, court proceeding. You can only do it for some reason under section 177. The 6 different reasons are listed out here. And only some parties can file an application to the court for compulsory winding up. Okay, I told you already, we have to know more regarding this one, unable to pay debt. Number 5, because for all the cases on compulsory winding up, more than 75% related to number 5. So this one probably is the most important one. And this one will be relied by the creditor. It means if you are a creditor, if you are outsider, and if you want to sue a company, if you want to wipe the company because of a debt, then you are going to rely on number 5. So we have to understand, right? We have to understand more what mean by unable to pay the debt. Because we have to understand the meaning. What mean by unable to pay the debt? If you sue a company for $1, the company is not paying you do you think that it's unable to pay the debt? Well, preliminary speaking, yes. Right? I asked the company to pay me. The company owed me $1. So I try to sue the company for $1. And the company is not paying me, then I can wipe the company. This is correct. But I don't think that will be accepted by the court as a reason to initiate the court proceeding for $1 only. So we understand what means by unable to pay the debt, because there are some preconditions we have to fulfill in order to initiate the whole thing under number 5. So what means by unable to pay the debt? The court, section 178, subsection 1 stated 3 different scenarios. So either one, right? Either one will be okay. Either one, not all. We look at B and C first, and then we'll back to explain what I mean by A. Well, A is more important. So let's take a look at B and C. What I mean by unable to pay the debt? B, when the court judgment is not capable to satisfy in whole or in part. What I mean by a judgment cannot be satisfied. So I'm the creditor. I'm the creditor. So this is the company, right? Hong Kong U Space Limited. I sign a contract with this company. So I deliver some computer to this company. So based on contract, I am entitled to payment for $1 million. Hong Kong U Space Limited is not paying me, so I sue Hong Kong U Space Limited in court, and I get a judgment. It means I win the case. I win the case. I won the case. I get the judgment. Here is my judgment. So I present my judgment to Hong Kong U Space Limited. This is a court order, and you have to pay me, right? Court order. But the company refused to pay or unable to pay. That will be B. It means I cannot, right? I cannot satisfy the court judgment, because based on the court judgment, I have the payment. But even I get the judgment, but I'm not capable to exercise my judgment. So that will be B. It means that if that happens, I can apply for another court order to wire up this company. So that's B. Do you get it? Do you understand? So that's B. So how about C? When you can prove to this expression of the court that the company is unable to pay the debt, it means that the same thing happened, right? Same thing happened. I signed a contract with Hong Kong U Space Limited. This is a company. Same. I deliver the computers to the company. I assume that I'm entitled to the payment, but I don't get the money. So the company owes me $1 million. But if this company is a public company, if this company is a public company, or a listed company, so it means that their financial statement is open for public inspection. So I check their financial statement. This company only has $100 in bank, only $100. But this company only $1 million. And I have very solid evidence. If that happens, then you can sue the company and make application to the court directly to write up this company. Do you understand the difference between B and C? Because for B, you have to get a judgment first. You try to exercise your judgment, and then you fail. Then you can make an application to court to write the company. But for C, if you have information to persuade the court that this company is not capable to satisfy my claim, then I can wipe the company directly. Right? You get my point here? Okay. So this is only one of the examples. By checking the financial statement of this company. If you have other evidence, and if you are capable to persuade the court, then you may try. Maybe you can succeed based on C. Okay? So I suppose you understand B and C. So how about A? What I mean by written demand is not satisfied. So this one is quite interesting. What I mean by written demand? A written demand, of course, is a written demand. So it means that you have to send a notice. You have to serve a notice to the company to request your payment. Not your payment. To request the payment from the company, right? Send a written notice. So we call it a written demand. But that's not just a letter. It must be in some specific format. What I mean by unsatisfied written demand? First, we have to understand what I mean by written demand. It means you serve, it happens again. You serve a letter, but in a prescribed format, Form 1A, something like this, right? There's only an appendix in the company law. So don't worry too much, that will not be exempted, right? That will not be exempted. You just know that you have to learn. Form 1A is a prescribed format, something contained in the company ordinance as an appendix. So it means you have to follow the format stated here. And then you serve it to the company to request for what? $10,000 or more. Well, this is not a big sum of money, I can tell you. Well, come on, right? $10,000 is not a big sum of money. So what I mean by written demand, when you serve a notice, based on Form 1A, something I just showed you, right, in the prescribed format, something you just copy, basically. You just copy from the appendix of the company ordinance, and you request for $10,000 or more than that. 10,000. Well, this sum of money is actually smaller than what? Small claims tribunals. Do you know small claims tribunal?
Yes.
Right? So now the old is 50,000, now it's 70,000. But here, 10,000 or more. So when a company is not capable to pay you within 3 weeks, then that will be regarded by law as unsatisfied written demand. It means you fulfill the condition stated in number 5. That means that you have the right to apply to the court to wipe the company. And that's what we mean by unable to pay the debt. Okay? Then maybe you want to ask a question. Just $10,000. It's not a big sum of money. And the company is not paying me based on my demand for 3 weeks. Then I can make an application to court to wipe the company. And I can do it by myself. Remember, it's not yet a court action. You can do it by yourself. You can download the form, right? And you can send a letter. So you try to do it tomorrow. Send a letter to Hong Kong Bank, right? And then to Citibank, and the Bank of China, and then to Alibaba. Write them up, all right? Kill all the company in Hong Kong. So easy, right? It's only 3 weeks. You just serve a letter. You download from the internet. You write the administrative office. Request for payment for $10,000. And after 3 weeks, when they have no response, then you have the right to apply to wipe the company, right? You can wipe Hong Kong Bank, you can wipe Citibank, right? That would be, well, very fun to do so. Right? You can wipe Alibaba, right? Very interesting, right? You can try to do it. Of course, not easy. Because that's only what? What? The entry ticket. That's only the entry ticket, right? It means that it's the minimum. The first hole actually is very hard. I mean, the number is not very hard for $10,000. The number, what you claim for, right? What you want to claim for is not really big numbers, not really difficult. Nowadays, $10,000 is not a great sum of money in the commercial world. So the number is not a big number, but the legal threshold will be very difficult to achieve. It means that you need to have extremely solid evidence, and you need to have a very strong case in order to satisfy the court regarding unsatisfied written demand. So we look at the second paragraph. The applicant must be capable to prove that the demand is undisputed. The applicant may fail if the company can raise doubt on his claims. Don't think that it is a casual requirement here. So I hope that you still remember something you learned from Hong Kong legal system. When you want to sue, no, not sue. When someone being arrested by the police and to be charged in a criminal court, so what will be the first hold for conviction? Do you understand that principle? In the common law, what's the principle? If you want to convict someone in a criminal court, what is it? Beyond reasonable doubt. You learned it in Hong Kong legal system. Is it right? You learned it in Hong Kong legal system. If you want to sue someone in a civil court, right? Not criminal, but civil court. So what will be the first hold if you want to make the other person liable? Not convicted, right? In a civil case, we are not calling it conviction. We call it liable. Right? So how to make sure that the defendant liable to your claim? What will be the first hold? Something like that. Any of you remember? What's the first hold for a civil case? Anyone? On the balance of probability. Yes, on the balance of probability. So if you try to make it as a number, so a criminal case means you have to prove 100%. Right? Beyond reasonable doubt means that sorry, if I'm a defendant, if I'm a defense lawyer, if I can raise a doubt, just one thing, and the prosecution cannot explain, then probably my client will be acquitted for the most year, right? Of course, that's only a principle, I can tell you. That's only a principle. That's not really realistic in real life. Now, I can tell you, right? I can tell you. Because you really insist on 100% certainty, no one will be convicted in the whole world. No one will be convicted. That's not possible. That's only a guiding principle. But anyway, right? Because here we're in the classroom, we just try to theorize. So, for a criminal case, if you want to convict someone, that will be 100%. And for a civil case, what I mean by on the balance of probability means 51%. What I mean by on the balance of probability, it means that your story is being more believable, right? So the civil lawyer, they are storyteller. I'm serious. Because the real example, for a criminal case, right, the real strength of the barrister will be his skills on cross-examination. You understand what I mean by cross-examination, right? You are the witness in the witness box, and I'm asking you questions, right? Cross-examinations. And to prove to the court that you lied to the court, right? You are the real criminal, right? You did something wrong, you killed someone, right? So by cross-examination, I try to show the court that this one is not believable. But that's very, I mean, not common for a civil case. For a civil case, cross-examination will be very unlikely. So 95% of the time, we don't have any cross-examination at all, because we don't have any dispute regarding the facts. So why we need to have cross-examination? Because we have dispute regarding the facts. We are not sure that whether you really did something wrong, right? Whether that you commit anything to this, in this sense, so whether you damage anything, whether you kill someone, right? We are arguing on facts, whether that actually happened. But for a civil case, like for a commercial case, normally we don't argue on the facts, because the facts are already agreed. For example, for defamation, do you understand defamation? 诽謗. Because there's something already published in the newspaper or in the magazine, right, or in the internet. So we don't waste time to argue on the facts, because the facts already proved it. We argue on what? We argue on the
Evidence.
We don't need to have evidence at all. Right? You publish a statement, Simon, right? So every time you say rubbish, you know the consequence. I will sue you, right? Okay. So I sue Simon in court for defamation. Right? It's a rubbish teacher. You already published it in the internet forum, right? You already published it in the next magazine, right? So why we need to argue on evidence? The evidence is here. You and me not going to argue on it, right? Because the statement already published. We only argue on what? Interpretation. The law, right? We argue on the law. what it means, right? Is it really an insult, right? Is it really defamatory? So we try to explain the law. So, I mean, as a civil lawyer, we don't argue on facts. We are storyteller. We are not going to cross-examine any witness. Unlikely, I'm not saying it never happened. It happens, but unlikely. So we are storyteller. We try to persuade the judge. My story, because the lawyers from the different sides, they are trying to argue on the same thing, but with two different perspectives. So you just try to persuade the judge. My story will be more believable than his story. It means my way to interpret this statement will be more believable than the other side, right? Okay, so I don't go too far. But just, I suppose that's what you learned in the Hong Kong legal system, right? The trial process. I don't go too far, but why is it so important? Because as a general rule, think about it. Is it a civil case or criminal case? Civil, of course, right? Civil case. So for a civil case, you only need to prove your case on the balance of probability. So it means that sometimes I can still get a judgment. Even my case still have doubt. Something unresolved, I can still get a judgment. Because for a civil case, the threshold is only on balance of probability. It means my story to be more believable, but not being undisputed. Not being undisputed. What being undisputed is almost like a criminal standard. So you get my point here. If you want to sue the company, if you want to bribe the company for unsatisfied written demand, yes, you can do so for $10,000 only. The number is not a big number, but legal speaking, the legal threshold will be extremely difficult to achieve because you have to prove your case undisputed, almost like a criminal case. What means by undisputed? It means a very high threshold, very high, extremely high, almost like a criminal case. That's why, right? That's why when you try to persuade the court for a court order to bribe the company, so based on the written demand, if something happened, right? If something happened, then the court will deny your application. Number one, something we call a cost claim or counterclaim. Do you know what is it? What I mean by cost claim or counterclaim? Something in civil procedure. For example, when I'm suing Angela, right, for breach of contract, I have to serve the statement of claim to read. You learned that, right? You learned that thing. I have to serve some document to Angela. So after Angela get my documents, she sue me back, right, for something else, right? For something else. It means that she try to persuade the court. Actually, I'm the wrongdoer, not her. That's what we call counterclaim or cost claim. When I sue her first, and she sue me back, right? Cost claim or counterclaim. So when you try to serve the written demand to bribe the company, and the other party sue you back, right? It means the company sue you back. And when the argument being genuine and serious, it means believable, right? Believable. And also existed the amount of the original debt. If you want to claim $1 million from the company, but the company claimed you $2 million. So if that happened, the court will deny your application for a written demand in order to bribe the company, number one. And there are some other reasons. The court may also decline your demand. For example, if that contract, right, if that involves a contract, if you want to sue the company to bribe the company based on breach of contract, so whether the goods have been duly received or whether the precondition of the payment have been met will also be considered by the court. I deliver some goods to the company. I suppose I am entitled to the payment. The court will also consider the contract. So whether all the conditions have already been fulfilled, when you still have something arguing based on the terms of the contract, then the court will not grant you the application to rob the company. But anyway, right? Anyway, no matter paragraph 1 or 2, right? No matter paragraph 1 or 2, the court stated clearly the demand from creditor may be declined if there's a general dispute of not having sufficient evidence. Just remember that the threshold is really high, really high, right? Unlike a normal civil case, and almost like a criminal case. Okay. How about the time of the commencement of the writing up? So remember, right? Remember, we are still in the first category, which is compulsory writing up, right? Two different approaches: compulsory writing up, voluntary writing up. We are still in compulsory writing up. So let's think about the commencement of the writing up. It is so important. It means the timing. It means the timing. You have to think about the timing. Before I answer your question, back to basic. What is compulsory writing up? Back to basic. What is compulsory writing up?
No choice.
No, I mean the nation. What's court action? The court action, right? Court order. Under court order means a court action. Right? It means a court action. Okay. Remember there's a court action. So what will be the time of the commencement of the writing up? That will be, we look at the first paragraph. At the time of the presentation of the petition to the court. It means when, at the time when you file your application and the documents to the court. Okay. But we may have a question here. Is there something wrong? Is there anything wrong here? And I'm telling you that the whole action commenced at the time when you file the petition to the court. I think there's a problem here. What's the problem here? 好似有啲問題喎，係嘛？ Is there something wrong here? Not something wrong, but is it a problem here? What I mean by compulsory writing up, of course, the court action. But also, I stated here, you look at here, a court order, right? Court order is a court action. But you can only have it when you get a court order. Application means that you are just seeking for help from the court. It doesn't mean that you will get a court order, because you may lose your case, right? So we can only do it when we get a court order. You understand that logic? And then we back to our problem. According to section 184, subsection 2, it states that the time of the commencement is on the time when you present your presentation to the court. It means when you file the document to the court. Here is the problem. The court order not yet granted. But according to the law here, right? According to the law here, the law presumes that once you file the application, the writing of process commences. 點解會咁 Do you get my point here? Right? You get my point here. But you need to have the court order, court action. It means that you only succeeded when you get a court order. But the law says that, the company ordinance says that, section 184, once you file a petition, then you assume that you already commenced the whole thing. Is there something wrong? We have to understand the logic here. Why? Because the writing up order with retroactive effect. It means the company will be treated as already under the writing up proceeding as to the date, despite the writing up order may only be granted on a later date. Why? You have to understand the reality. Because for all the civil action in Hong Kong, I think that will be the same in other common law jurisdictions. Our focus is on procedural justice. It means that we have to make sure that every single step shall be complied with the law. And it also means that it takes a long time for what? To finish the whole court proceeding. So I can tell you that a civil case in Hong Kong for a company winding up, that's very common to last several years, starting from the day of your submission of the application until the day you get the order. Well, that will be a little bit faster for a criminal case. Because you have to understand the nature. In a criminal case, probably someone already in the jail, right? Already under custody. So we have to do it faster because that considers freedom of someone, right? Being arrested, detained. So we have to do it fast. If we make mistakes, we cannot compensate when you're losing your freedom, right? The thing about a civil case is almost all about money. And the court is very busy. And the lawyer, they like to abuse the procedures, to take advantage of the procedures. So that's very normal for a civil case to last several years before you can get a court order. Then you have to think about the consequence. If I file the application to court to rob a company, but I need to wait 5 years before I can get the court order, then you know that I already used it, that thrifty example. A big fish breeding, all the sharks smell the blood, and they want to have a bite. It means all the stakeholders, they try to do something in order to protect their own interests. Because they learned that the company is in trouble. And then you know what will happen. A lot of, right, wrongdoers, a lot of people will try to do something to the company to get the money out from the company. So that's why the law needs to presume that once you file the application, the court will presume that the commencement of the winding up. And remember, it's a court action. It means once you file the application, the court will take a look on everything. So if you are doing anything wrong, you have to be careful, because that's not just a civil case. If you lie to the court, if you're doing anything in order to deceive the court, that will be what? Contempt of court, right? Contempt of court, and that is criminal. 藐視法庭, right? So that's the way to protect the company. The petition here. But it takes a long time to get the order. You can only have it 4 years later, right? So lots of bad things will happen in this period of time. So the court must assume that the whole thing actually commenced once you file the petitions. So any wrong thing being done here will be contempt of court. The Big Brother is watching you here. And that's the reason that we assume that the whole thing commenced at the time when you file the application, right? Two more pages, then we have a break. But please remain here because you have to do the questionnaire, right? It only takes you a few minutes, okay? I told you already, there's a very important person in the writing process, and that person, we call that person as a liquidator. But for compulsory writing up, because of the whole proceeding here, before we can have the real liquidator, we need to have someone called as provisional liquidator. What I mean by provisional? Temporary. Something like temporary. 暫時，係咪？暫位，暫時 temporary. Provisional liquidator. Why we need to have provisional liquidator? Look at here. Because we filed a petition, right? And you only can get the court order 4 years later. But the court already assumed that once you file the petition, the whole thing's already commenced. So someone need to take care of what happened in these 4 years. And that person will be the provisional liquidator. All right? Who will be the provisional liquidator? Number one, the court appoint provisional liquidator. Because compulsory winding up is a court proceeding. So who is going to appoint? The court, right? The court may appoint a provisional liquidator at any time after the petition of the winding up. After this date, stop right here, right? After this date. Who will be the official? Who will be the provisional liquidator? Maybe official receiver, OR, in this government department, right? The court will appoint the department, the whole department, to take care of it, or anyone. Think fit. Normally there's a CBA, right? Normally there's a CBA, but anyone. So what happened? Once you appointed the provisional liquidators, no legal proceeding can be brought to be continued except with the leave of the court. No one can sue this company because the company is dying, right? The company is dying. No one can sue the company. If you want to sue the company, you have to notify the court first. The court will keep your claims in the file, right? But you cannot do it at your own will because the company is inviting a process. And all the invoice letters, they must state that in their letterhead, this company is in the writing of process in order to alert the third parties to understand that this company is in trouble, right? So if you're the bank, don't lend any money to this company, right? If you are the businessman, you have to be careful because the company may not be capable to pay you back. And very important point for the last paragraph. The primary purpose in appointing a provisional liquidator is to preserve the company asset during the time gap. What's the time gap? Here. So don't mix up the duty of a provisional liquidator. Don't mix up the duty of a provisional liquidator and an official liquidator. The primary duty of a liquidator is to handle all the claims and distribute all the assets, but not a provisional liquidator, because court order not yet granted. So the provisional liquidator, the primary duty is to preserve the asset. It means to keep everything all right, right? You want to claim for ownership, okay, let me know. I keep in file, but don't try to steal the money, right? Don't try to take an asset. That will be handled once the court order being granted, when the official liquidator take control, all right? So that's the main difference between provisional liquidator and official liquidator. Okay, so we have a breakfast, but please remain here. You have to do the questionnaire, right? And then we have task 15 minutes later. Okay? Okay, so 搞掂。好。好。唔係我嘅，佢哋錄音。OK。好，一晚。
係test。 機會。中間嗰頁咧，其實有張白紙嘅，咁其實呢個咧就係講俾你聽係有 Teacher A 同 Teacher B 嘅。咁你哋之後填咧係填第一版、第二版同埋第四版嘅啫。Teacher A 係 default 咗 Teacher A 係邊一個 ？Teacher B 係邊一個啊？同學？
你咪我就咁寫 CLS
咁下邊呢個 CLS 邊個咯？
全課程同埋科目寫文嗰樣嘢全部做㗎啦，明㗎啦佢喺度收㗎。
係記得我要收晒所有嘅嘢，包括嗰張白色老師嗰張紙都係 Teacher A、Teacher B 嗰張紙都要收翻嘅，唔該。
俾個章你啦，一係如果你唔得閒。
記得㗎。
冇，
最低呢隻最邊啊？
係啊，佢話淨係做到1、2、4版啊嘛，啱過嚟講。
或者而家放喺級別級嘅頭頭，如果真係放嘅話。唔該晒。唔該。等等啊，唔好意思。唔該晒。唔該。
如果啲堂冇填嘅話，就咁寫翻。
你可以嘅。 其實可以唔使寫㗎啦。Thank you。唔該晒。可以食翻入去嗰張紙。
哦，
食翻就得㗎啦。唔該晒。Thank you。
Were you able to hear what President said?
Yeah, I mean, I think that's fine.
請問在座各位同學仲有冇人未交文件或者多咗出嚟㗎？唔該晒。
咗一段時間。
係啊，食一次啊？
嚇？
食一次啊？
食唔一次都要㗎喎，慢慢倒落去咯。
對住食啊？
唔係啊，佢金堂短咗啊嘛，要做嗰啲蜜卷，咁我少少蜜卷咗咯。
我再後邊食後邊食都唔俾你嘅，得好多面就難睇啲。
唔係佢入嚟我唔食㗎啦。佢一開始教我唔會㗎，叫你自己諗下啫。呢啲係老師識答用嘅招數嚟㗎嘛，自己諗下啦，咁簡單你咪唔識我。
保我理解佢可以做得到。佢一段時間佢會 notify 你話你未交上去，所以即係佢都會話你未交嗰個人數，我哋唔會即刻先考慮。我記得係但我唔係100%，我都收明顯係啊，我唔記得咗，呢個我唔直接記得，但我 roughly 記得好似係，但冇咗 member 係一層。你都會嘅，之後嘅但我唔係100%肯定，呢個可能真係要記得。我唔係好記得100%，即係點樣都方便嘅著有呢架喺度。你睇翻嗰張方面，即係嗰張 incorporation 講，你睇呢張方要做咩嘅？即係要由因為我所知唔係，佢通常係覺得有問題，佢應該會話俾你。佢應該 notify 你，因為你嗰個方面有你個 contact， 佢應該會話俾你聽。佢話俾你聽你有嘢漏咗，佢應該話俾你聽有嘢漏。我唔知，不過佢就唔出聲俾你。我唔係100%肯定，我都話我唔係100%肯定，但係我記得佢有可能係錯，但係佢會話俾你聽，你幾時來要翻我講出嚟。有可能，因為中途你都有可能缺失嘅喎，冇所謂嘅。中途你都可能有時會冇咗嗰個位，都唔知導致都係你中途你都要做處理師，唔可以冇晒第一層，唔可以 sell 呢個就玩因為佢哋嘅組成部，嗰個唔係組成部特別係一個標個位。我記得好似係咁，我唔係100%肯定，你都要確認。Okay, be back to class. So before the break, right? Before the break, you learned about the provisional liquidator. So I suppose you understand what I mean by liquidator. So liquidator is the person to take over the company. And the primary duty of a liquidator is to handle all the claims and then to distribute all the assets based on the claims he received. But that's not the case for a provisional liquidator, because we have to understand the time gap here. Right? We have to understand the time gap here. In a civil case, normally it takes a long time. So sometimes it takes a few years. Right? It takes a few years. So during the time gap here, we need to have a provisional liquidator. So that person to take care of the company in the time gap. But don't mix up provisional liquidator and official liquidator. Because the provisional liquidator is the one to safeguard the company, to keep it, healthy, right? To keep it, to make it still exist, and not being stolen by anyone, and not to be used by anyone. So the primary duty of the provisional liquidator is to preserve the company asset during the time gap. And that's a very important concept, right? Very important concept. Of course, one day we are going to have the official liquidator. At the time when you get the court order. So we look at the first paragraph. The official liquidator shall be appointed after the writing order has been granted. So only at the time when you get the court order, then you are going to have the official liquidator, the real one, right? The real one. In reality, right? In reality, most of the time, the official liquidator and the provisional liquidator, they are the same person, right? Just the status becoming different. Once you get a court order, the provisional liquidator turn into official liquidator. Right? Normally, that will be the case. But I'm not saying that it must be, right? I'm not saying that it must be. Because that's the whole thing under the court supervision. So the court can appoint, anyone, right? Anyone. But normally, the same person. Okay. So, once a liquidator being appointed, the liquidator shall have the following powers in terms of operation. Because you have to remember that once the official liquidator being appointed, so that person having due capacity, on the one hand, to maintain the operation of the company, and on the other hand, to handle all the claims of the debt. But sometimes that will be good for the company to maintain the operations. So even the company in a winding up process, or even the company cannot pay all of that, but it doesn't mean that every single part of the company is making a loss. Do you know a concept we call a cash cow? You know what we mean by cash cow? So it means that certain part, certain duration, certain department of the company still generating cash, still making money. That's absolutely possible. Maybe 70% of the company is losing money, but 30%, one or two departments, still making profit. So even you are the liquidator, you already take control of the company, but that will be profitable. That will be good for the company to maintain some operation. So there will be two duties being imposed on the liquidator. On the one hand, to maintain the operation. On the other hand, of course, to handle the claims, right? So they may carry out at the same time, in parallel, right? 同步進行. So in terms of operations, the liquidator, of course, can handle all the claims or legal action. Now you are the official one, right? Now you are the official liquidator. You control everything, including all the legal proceedings. Of course, you can carry on the business if that is profitable. In facilitating the winding up, it means that when the company is still making cash, making income, so let's keep it on. Or to make any compromise arrangement with creditors, you can start your negotiations with creditors that they want to pay from the company. Or you can make any compromise with the shareholders. Remember, certain legal entity, maybe one of the creditors is the shareholder. And you can negotiate with the shareholder. You can negotiate with anyone, any third parties. And of course, the liquidators, they can deal with the asset of the company. For example, sell the properties if it can generate cash for the repayment of debt. So that may be advisable to do so. To sell the property, to execute, all kind of documents, contract, deed, to draw a check upon agents, anything that may be necessary for winding up affairs of the company and distributing an asset can be carried out by the liquidator. So all of them are just common sense stuff. And what's more important thing is that as a liquidator, remember your primary duty. So now you are not provisional liquidator, you are official liquidator. So you can start your work by distributing assets, 可以查掘間公司 and then to handle all the claims, right? Everything. You can do everything, provided that it is helpful in the winding up process, including selling the asset of the company, if you can sell it at a good price, right? Common sense stuff, just not really difficult to understand. But you may want to ask a question. Remember that a liquidator is only an outsider. Is it correct? So normally, who is in control of the company? Normally, who is in control of the company? I mean, director. Yes, director. When the company is still normal, when the company is not in the winding up process, who manage the company, who operate the company, of course, directors. And you may want to ask the questions, because the liquidator is only an outsider. And the liquidator needs to, take control of everything. And to handle all the claims, including asset, liabilities. So how can he fulfill his responsibility? So how can he know everything from the company? Because he's an outsider, right? It's an outsider. And if the company is only a private company, it means that financial information, or normally all kind of information, are not available to the public, including debt and liabilities. Because the financial statement is not for public inspection for a private company. So how can liquidator to get all the required information? One thing, a statement of affairs. Right? A statement of affairs. So what is it? A statement of affairs is a document that the directors, they have to provide to the liquidator within 28 days after the writing of order has been made. The directors, they have to submit a statement of affairs according to section 109 to the liquidator, stipulating the details concerning the company assets and liability. So it means that you have to fill in a form that includes information of all your assets, all the claims, and all the liabilities. So in order to give a full picture for the liquidator concerning this company, something like this. So this is the statement of affairs. So you can download from the company registry an official form. So you have to state all the information here. So everything. Right? I just want you to take a look. That will not be example, of course, right? Because we are not studying company secretarial practice. We are studying company law, so you don't have to worry too much about the procedure, right? But anyway, so this is the statement of affairs, and directors, they have to submit this form to the liquidators. So the liquidator is going to have a clear pictures on everything. After the statement of affairs have been received, the liquidator shall submit a report to the court. Why? You have to remember that under compulsory writing up, liquidator is a person appointed by the court. So he's accountable to the court, and he's an officer of the court. It means he's representing the court in executing the writing up order. So once you get the statement of affairs, as a liquidator, you have to report to the court, right? You have to write a report to the court. On what? Number one, the estimated amount of asset and liability. A rough estimation regarding the debt and liability of this company. The cost of the company operation failure. Why this company end up in liquidation? So you have to say the reason. Help the court to understand. Because the court appointed you to take over this company. So you have to report all the required information. This one, very important. Whether further inquiry shall be conducted from the company affairs. Because as a liquidator, you are accountable to the court, right? So if you found anything suspicious, any criminal activities, embezzlement, corruptions, forgery, 造假文件, 虧空, 貪污, right? Anything, money laundering, and you have the duty to report to the court. Now, I want to ask you a question. In the common law, right, or in Hong Kong, do you have a duty to report a crime to the police or any authorities? Do you have a duty? Do you have a legal duty? Do you think that you will be charged when you learn about a crime, but you keep silent on it? When you learn about a crime, you learn about that your neighbor, they are making cocaine, right? Or they are making bombs, and they have guns. You learn that. Right? You learn that. You're very certain of that because you are, he's your neighbor. But can you just remain silent?
Yes.
Do you think that you will be arrested for some reason and to be charged by police because you are not reporting a crime? Yes or no? No, you don't. Right? You will not. Because we only have a moral obligation to report a crime in Hong Kong, right? Generally, we only have a moral obligation, but we don't have a legal duty to report a crime. Even you witness a crime, right? Even you learn about a crime. But provided that you are not assisting the crime, if you assist the criminals, if you assist criminal activities, then you will be charged for incitement, right? 教唆. Or you are offering assistance to a crime, then you can also be arrested. But if you are just remaining passive, right? I learned about a crime, but I do nothing. Well, you will not be arrested, right? But even sometimes the police, they will threaten you right, by saying that you have to, otherwise you will be in trouble. But they are only saying that you will be in trouble. They are not saying that you are illegal. 佢淨話你有麻煩啫，佢冇你犯法, right? But you have to understand that normally we don't have a duty to report any illegal activities unless you are in some special positions. And liquidator is in a special position. Because as a liquidator, if you observe that something abnormal, and if you have reasonable suspicions on illegal activities, especially criminal activities, then you have duty to report to the court or to the police. The CCB, you know CCB, Commercial Crime Bureau, 商業罪案調查科, or the ICAC, or anyone, right? Because when you are a liquidator, you are in a special position. And the general assumption is not applicable to you. But if you are just a normal citizen, you don't have duty to report the crime, right? You can remain passive, but remember, you cannot assist the crime. If you assist the crime, you will also be liable to criminal liability, right? So, if you are a liquidator, if you find anything wrong with this company, you have to report to the court. So normally that involves corruption or forgery, right? Or money laundering. Okay. So it seems like the liquidator is the one being so powerful. Because once a liquidator appointed, so I can tell you that the directors, they're no longer in control. And once a liquidator being appointed, and the members in the general meeting, they are no longer in control. So you can forget about special resolution, auto resolution, board resolution. No more having any value at all. Because in the wider process, liquidator is the king, because he's the one in charge, right? So it seems like he can do anything without any restriction. That is almost correct, but not entirely correct. Because a liquidator, to a certain extent, he controls everything. That's correct. And he can somehow ignore the board of directors, and he can ignore the shareholders. Now he's the one in control. And remember, in the court writing of the liquidator being appointed by the court. So he's even more powerful, right? Because he's under the court order. So no one can against the court order. But that will be contempt of court, right? Not even the government, not anyone. But I'm saying that it is almost correct. I'm not saying it is absolutely correct, because the liquidators actually under restrictions by some organs, right? I mean, they have to think about, there are some entities here, and they have to think about that. Number one is official receiver. Any of you still remember official receiver? We call OR, right? In daily practice, we call OR. If you're in the CPA firm, if you're in the law firm, you understand the term OR, right? RO means registered office, normally in a law firm, right? When a lawyer or in the law firm, when someone saying RO means registered office. the official corresponding address of a company. When you serve a notice to the RO, it means that it deemed to that notice will be valid to be received by that company, right? So RO. And OR in the law firm or in the legal profession, it means official receiver. So there are two organs. They have some influence to the liquidator. And the number one is the official receiver. Because the law says that. The law says that, section 204, the official receiver has a statutory duty to supervise the work of the liquidators on the company being warranted by the court. Right? Only because we have another mode of writing up. We are going to learn about it 2 minutes later. But the official liquidator is the one who take care, not take care, to supervise the liquidators when it is a compulsory writing. And the law says that. What I mean by supervise? So if any creditors or shareholders, if they want to complain, the liquidators, right? You find that they did something wrong, or the liquidator is doing something unreasonable, right? Nonsense, or that may even harm the company, and you can complain to the official receiver, and they have the authority to supervise the liquidators. So after they get your complaint, then the official receiver can inquire into the matters. For example, for what? Require the liquidator to answer the inquiries, right? They just ask questions. So while you are doing that, we are having complaints from the shareholders, from the creditors. From the creditors. You are doing something nonsense. You are doing something unfair, right? You are something which is harmful to the company. Or they can apply to the court to examine the liquidators on oath. It means to testify in court. So that will be very intimidating. It means to send a summons to the liquidator. You have to attend the courtroom, right? The judge will be here, and someone will ask you questions, and you will testify, right? Testify, 即係作供, right? Testify in court under oath. What mean by an oath? 宣誓, right? Under an oath, affirmations, something like that. But you have swear that to the Bible, or depends on whether you have religion, right? I'm saying the whole truth, nothing but the truth. You heard about it in the movie, right? On the TV. 事實及事實之全部, something like that. So that will be very burdensome, right? So you have to answer questions before the judge and in the courtroom, right? And the official receiver, they can also investigate the books and record of the liquidator. They can ask you to present your, accounting record, right? What you're doing here, why you are selling an asset to yourself, why you are selling an asset to your friend, right? I'm the liquidator. Well, I find that, well, this thing is a good thing, right? It's worth $1 million. But Simon is my good friend, so I sold it to you at $10. Then some shareholders learn about it. The shareholder complains to the liquidator. So I have to answer, right? If I answer not being satisfied to the court, then I will be in trouble, right? So number one, the liquidator, yes, he's in control. He's having a very wide authority, right? He can almost do anything, but not absolutely, because sometimes you need to consider the supervision of the government department that we call official receiver. If you are not happy, right? If you are stakeholders and you are not happy with the liquidators, you can try to complain to the official receiver. Another organ, entity that may also supervise the work of the liquidator, and this committee or inspection. This is not a government department. This is only a committee. So what is it? What kind of committee? So you have to know that after the writing of order has been made, right? So after you get the court order, the creditors and shareholders, they can decide whether they want to apply to the court and to form a committee. Creditors and shareholders, remember, no directors, right? No directors, only shareholders and creditors. Creditor is right? It means the company owns the money, to the creditors. So the shareholders and the creditors. So after the writing of order being granted, they can apply to the court. So it means that subject to the approval of the court. Remember that. It's a whole thing supervised by the court. It's a court action. So you can apply for a committee, but you need to have approval from the judge. So the committee include creditors and shareholders with a proportion agreed between them or being determined by the court. So you can appoint a committee, say like 5 members, 3 shareholders, 2 creditors. If you can agree on it, that will be fine. But if you cannot agree on the compositions of the committee, then you seek for court instruction. Okay? Because it's a court action. So everything finally should be determined by the court. So the committee shall meet at fixed time period or by the call of any members. There's no special rules. Then don't mix up a committee of inspection with the general meeting of the members. So forget about 40 days notice or 21 notice, not AGM, not STM, right? No. Don't apply all this concept to the committee. This is only committee. So you can set the rules in any rules you like, provided that you get approval from the court. So you can meet up every week, every month, or every day, up to you, right? Up to you. Last thing, remember, the committee is to assist and also to supervise the work of the liquidator. Assist and supervise. So sometimes you help by giving an opinion to the liquidator. For example, right? For example, maybe there are only a few creditors. When there are 3 creditors, for example, right? There are only 3 creditors, and all the creditors, they are in the committee. And remember, the primary duty of the liquidator is to handle the claims of the liquidator. So sometimes their opinion can be helpful, because you can seek for opinion from the creditors. How you want to get your claim. Are you okay with cash, or you want asset, right? If I pay you cash, if you prefer cash rather than having the asset of the company, would you consider a discount? Do you understand the point, right? You can try to negotiate with the creditors. So if the creditors, they are in the committee, and that may be helpful, right? That may be helpful. So it means that you can help the liquidators to do his work. And you can also supervise his work, right? You can supervise. But of course, if there are anything wrong, you can only complain to the official receiver, because you are not having statutory authority to stop the official, the liquidator in doing anything, right? You don't have such authority, but you can supervise, right? And you can complain. Finally, so very tricky stuff. Then I highlight in red. The liquidator has a legal duty to regard the direction given by the committee. Right? You have to understand regard. It's a very tricky word. What do you mean by regard? In Chinese, 顧及. What do you mean by 顧及? What do you mean by regard? Well, regard something like consider. If the law states something like this, as a liquidator, you are subject to the decision of the committee of inspection. Then you understand what it means. When you are subject to, right? When you are subject to, it means that you have to take the instructions from the committee. But what you mean by regard, 顧及. So very tricky. Something, it means that when you are making your decision, you have to think about, right? You listen to the advice being given by the committee, but you are not subject to the committee of inspection. Because remember that you are appointed by the court, and there's only one person above you, and that's the judge, not the committee of inspection. So you only need to regard to the direction given by the committee, right? But not subject to it. And that's very important, all right? Remember that. So when you are a liquidator, and when you are not certain whether you should do something or not. What can you do? Because when you are doing something wrong, you may be liable, and you may be sued by some stakeholders. That may be the creditors or shareholders. If you want to play safe, what you can do? So a practical matter. You can what? Instruct your lawyer and to seek for further instruction from the court to confirm something, right? That's what we call as validation order. You can get a validation order from court. It means that when something is really controversial, you think that it's a good decision, but you have opposition from the Committee of Inspections, or you have complaint from some of the members, so you are not really certain whether you should do it or not. So you can try to make an order. Sorry, you can make an application to court, instruct your lawyer to get a validation order from court in order to confirm the validity of your decision. Then you will be safe, right? But once you get the validation order, no one can sue you because you are being backed up by the court. But also, I can tell you that that will be very difficult to get the validation order. And if you are doing it without serious consideration, you are doing casually on, say, like on everything, because you are always, afraid of liability, right? You are scared of the liability, so you try to avoid from all kinds of trouble. So you try to make application to the court to validate everything. Then you will be punished by the court to pay all the legal costs, including the other side. So you should only make application when something is so serious, right? When something is so serious. But I want you to learn about validation order, at least what it means. Well, one day you may heard about it from Deloitte. So finally, what happened? When the liquidator, based on the statement of affairs, so that's the information from the directors. From the directors, and act according to the direction of the court. Number one, most important, as a liquidator, for a compulsory winding up. So you base on the information from the directors, and also based on direction from the court and the Committee of Inspections, and you try to distribute everything left to the creditors and shareholders. Remember your primary duty as a liquidator, right? You are not the person to keep the business forever running, but to handle the claims. The operation can remain active, which is helpful to the winding up process. But remember, ultimately, you kill the company. Right? That's your purpose. So when you finish everything, when you want to release from your duty, because as a liquidator, you are having a very burdensome duty here. You're having a heavy shoulder because you are always accountable to the court. So if you finish everything, if you want to release from your duty, you have to apply to the court order because the court appoints you as liquidator. So once you get the court order of the court to release, then the company will be officially dissolved. Remember, right? Company dissolved. Winding up is a process. The liquidator, within 14 days, deliver the copy of the order of court to the company, to the CR for registration. So if you search a company using their database in the CR, and if you find a court order for winding up, you know that that company already terminated and confirmed with a court order. So you know that RIP, the company already rests in peace. All right? So that is all about compulsory winding up. But I hope that you still remember, apart from compulsory winding up, we have voluntary winding up. So what's voluntary winding up?
Suicide.
Suicide, yes. Very good term. Very good term. I really like it. Suicide. kill yourself, right? You jump, I jump, right? To kill yourself. Suicide, right, very good. Because apart from compulsory winding up, remember that we also have voluntary winding up. So what is it? It means that you try to put up your company by its own initiative. It means that this time the court is not involved. You are not making application to the court, but you are using the company's own mechanism to wind the company. So what is the company mechanism? There are only two organs in managing the company. What are they?
Board of directors.
Board of directors and
AGM.
and the what?
AGM.
Not AGM. The general meeting or shareholders general meeting. Because we only have two organs in managing company. Right? I hope that you understand. If you still don't understand and lecture 10, you will be in trouble, right? You can think about suicide, right? But this is something you already learned, right? A few weeks before. And this is the last lecture, come on, right? It's the last lecture. So don't do it. Don't do it. 生命值我覺得死係解決唔到。Okay. So what I mean by voluntary winding up means that the company is using its own mechanism to terminate its life. And what the company mechanism? I just told you the board of directors and the general meeting. So it means that we are still relying on the company organs, right, in a normal operation, and also to use it to wind the company. And we can do it. And when we are trying to do it, we call it voluntary winding up. So under voluntary winding up, by comparing to compulsory winding up, in a voluntary winding up, the members and directors, they retain a high degree of control over the winding up procedure. And that is quite different from compulsory winding up. Because in the compulsory winding up, the court takes over everything. But in voluntary winding up, directors and shareholders, somehow they are still in control, right? They are still in control. So how can we initiate voluntary winding up? Right? How to do it? Three different reasons, three different grounds, right, that we can initiate voluntary winding up. And number 1 and 2, actually, very similar to compulsory winding up. If you still remember the 6 different reasons under section 177 to initiate compulsory winding up, they are the same for voluntary winding up. For number 1, when member passes special resolution without any reason at all, but you don't need to have any reason. Just I like to do it. If you can secure special resolution, then do it. Right? You don't need to have any special reason at all. Number 2, something similar to compulsory winding up. You pass an ordinary resolution based on some special provision in the article. For example, right, when you have a statement, when you have a provision in an article saying that when a company is losing money for more than 5 years, then the member should apply to the court for winding up or to initiate the voluntary winding up. Right? It means you have based on something stated in an article, then you are using it as a reason to wind up, provided that you can pass an ordinary resolution. So for 1 and 2, for the members wind the company by passing resolution. This one without any reason, this one with a reason. And the last one, directors. So now the turn for the directors. For voluntary winding up, if more than half directors resolve to deliver a winding up statement to the company registry under section 228, right? When the solicitor, they mention 228, it means director voluntary winding up. 律師樓佢哋好中意講話成228，即係意 right? When the lawyer, they mention 228, in Cantonese 228 means they want to wind a company by the directors. So remember that, right? Remember that. 大班律師，大嘅，公務。So you understand the legal jargon of the lawyers. That will be helpful. For number 3, if the directors, what's the general rule in underlying the operation of the board of directors, only one thing, simple majority. We don't mix up, right? Poll voting, so again, no. Shareholding, no. Special resolution, auto resolution, no. No, nothing. Because in the board of director, we only have simple majority. Just raise your hand. And more hands saying yes, it means yes, right? More hands saying yes, it means that's all, right? No special resolution. Don't mix up, right? Don't mix up. So it means that when you can pass a simple majority resolutions here, and to deliver a statement, just to deliver a statement to the company registry, then you can initiate voluntary writing up. So this one, 1 and 2 for members, shareholders. This one for director, all right? So how about the time of the commencement of the writing up? Try to recall what we learned for compulsory writing up. The law assumes that the whole thing commences at the time when you file the petition. But that is only presumed to be. Why? Because in a compulsory writing up, there are 2 stages. You have to file the petition, then you have to handle the court proceeding. That may take a year or several years. And then once you get the order, then you can actually start the whole thing. Because we have this concept, so we have to think about provisional liquidator and official liquidator, because we have 2 different stages. Do you get my point here? Right? Presumed to be, and actually you get a court order. So we have to think about the time of the commencement. That would be very tricky for a compulsory writing up, because the court being involved. But in a voluntary writing up, that's not a court actions. We are just relying on the company's own mechanism. So once the organs in the company make a decision, and that will be the time of the commencement of the writing up. We don't have to wait a few years, right, before the whole thing can officially start to work. And we don't have provisional liquidator, and it means yes, and the official liquidator, not exactly that concept, because once you start, you start. So we look at the time of the commencement. Number 1, a voluntary writing up commence when the resolution of the writing up being tested. That is for case 1 and 2. When you pass the resolution, that is the time of the commencement of the writing up for the voluntary writing up. And for C, when the directors pass a resolution by showing hand, simple majority. But when they file the form to the company registry, you decide on it, and then you file the form. That will be the time of the commencement of the writing up. So if the form being filed on 10th of January, so that will be 10th of January to be deemed to be the commencement of the writing up. All right? So what is straightforward by comparing the compulsory writing up? But something quite tricky. We look at here again. You just learned about compulsory writing. And I also explained to you what I mean by voluntary writing. Try to recall what you learned about compulsory writing up. One of the reasons, according to section 177, in order to initiate compulsory writing up is what? Regarding payment of debt. When the company is unable to pay you, then as a creditor, you should initiate compulsory writing up. Yes, right? You remember that?
Yes.
So it means that if you are a creditor, normally, where will you be? You will be here. Am I correct? Because voluntary writing up is all about using the company internal mechanism. You understand that concept, right? You understand the concept. So if you are a creditor, you should be here, not here. Look at here. Why we are creditor voluntary writing up? I think you understand what I mean by members voluntary writing. You already learned by passing a resolution. And you understand that director. They pass, they vote, right? They raise hand, and then they file the form. So you understand this one. You understand this one, but how about this one? Why creditor voluntary writing up is under the heading of voluntary writing up, but not here? Do you understand my question?
Yes.
Right? 你明唔明啊？明唔明我問緊乜嘢？ So anyone know the answer? So you have to be careful. Right? You have to be careful. If you understand my question, then you understand the dilemma here. It seems to be illogical, because if you are creditors, you should initiate the whole thing by compulsory writing up and under a court action. Because you are a creditor, you are outsider. You should not rely on the company-owned mechanism. That is true. I can tell you. That's absolutely true. And this concept is perfectly right. But one thing you also need to learn. Because when the members, when they pass an order resolution or special resolution, when they want to wipe the company, right? Members, it means under category 1 and 2. The directors need to do one thing. And that is to present a statutory declaration of solvency. What I mean by statutory declaration of solvency? It means that the director, they have to confirm that the company is capable to settle all the debt and claims in the coming year. 12 months in coming year, right? In the coming year. When the directors fail to do so, the members, remember the members, right? The members, they are only the members. They don't have the financial statement. They are not the one in control of the accounting books, so they don't know. Right? They may know, but they may not know. But anyway, if the members, they pass a resolution to wipe a company, they try to ask for the statutory declaration of solvency. Why we have something like this? The underlying rationale is that you can wind up your company by your own mechanism. You have the right to do so. You don't need to have approval from anyone, not from outsider, not from government, not from the judge, provided that you can settle all the debts. It means when you're winding up process, it's not making any outsider in trouble, then you have the right to do so. You have absolute right to do so. And that's why the law requires statutory declaration of solvency. You get a point here. Do you understand? Right? It means when you can take care of your own, you are not creating trouble for the outsider. Freedom, right? What's the limitation of freedom? The limitation of freedom is you cannot what? Affect the freedom of the others. It means you cannot cause trouble to the others. When you are not causing trouble to the others, you can do anything you like. And that's the underlying rationale here. So after the members pass a resolution to wipe the company, the directors need to present a statutory declaration of solvency to confirm that the company is healthy to handle all the debts. But if the directors fail to do so, then the whole thing will turn into creditor voluntary winding up. Do you get my point here? So it means that basically we don't have creditors voluntary winding up. If you are creditor, if you think about winding up a company, you have to initiate compulsory winding up. You have to think about that as a court action to apply to the court, sue the company, and then to wipe the company. Why it turns out to be a creditor voluntary winding up? Because as a creditor, you are just passive. You don't want to initiate any winding up at all. Only the members want to do it. But when the members try to do it, the company is actually insolvent. 資不抵債. When the companies cannot handle that, so based on the law, the whole thing needs to be turned into a creditor voluntary winding up. Because you have to understand that what I mean by voluntary winding up, when members or directors, they are still in control. When your company is solvent, then you can do it. And you are the members. You have the freedom to wipe the company because your company is healthy. You can handle all of that. So you have the right to kill your own company, right? Perfectly fine. But if you try to do it, but in fact you are insolvent, then who will be in control? Creditors in control, not you. So the whole thing turns into creditors voluntary winding up. So you can say that, right? You can think like this. Actually, there's no such thing as creditor voluntary winding up. No such thing. As a creditor, if you want to wind up, compulsory winding up. But just sometimes when the members, they try to wind up the company, and the company is actually insolvent, then the whole thing turns into creditor voluntary winding up, and you are, as a creditor, involved in it. And you don't have a choice, right? You are just passive. I don't want to, but that's the law. Because when a company is insolvent, it means you cannot handle the debt. It means the third party will be affected, the outsider being affected. Then they are in control, not you. Okay? So let's think about when members voluntary winding up first. If the statutory declaration can be made to the members, then the general meeting can appoint the liquidator. Simple, right? If a statutory declaration of solvency can be presented to the members, it means the company is solvent. Then the members, right, you can do anything you like. So you appoint liquidator. And the directors cease to operate the company. So during the liquidation process, the members shall have the right to remove the liquidator by special resolution. Remember that in voluntary winding up, the company, in members voluntary winding up, the members still control the company. Control the liquidation process. So they have the right to appoint liquidator, and they have the right to remove liquidator. It means if they are not happy with the performance of this liquidator, they can appoint another person. You don't need to have approval from anyone, because it's not a court action, right? And your company is solvent, so you can always do what you like to do. Okay? So that is members voluntary winding up. But one thing remember, if the liquidator, if during the winding up process, even the director can present the statement of solvency, but later on, when the liquidator is really handling all the claims and the financial statement, and he formed the opinion that the company cannot settle that, it means that the declaration of solvency is not accurate, and it's not correct, it's incorrect. Then the liquidator can call all the creditors and turn the whole thing into creditors voluntary winding up. So the point is, just remember who is in control. For compulsory winding up, the court in control. In what members voluntary winding up, members in control. Why you are in control? Because your company is solvent. You are not hurting the outsider. So you have the right to appoint liquidator. You have the right to remove liquidator. And when you want to wipe a company, but your company is insolvent, then the whole thing turns into creditor. So creditor in control. So that's all. You have to understand the logic that everything's so simple, right? So if during the winding up process, if the liquidator found that the company is actually insolvent, even with the statement of solvency, it means the statement of solvency is incorrect, then the whole thing turns into creditor voluntary winding up. Okay. So creditor voluntary winding up. When the member passed the resolution to wipe the company, but the director failed to provide the statutory declaration of solvency, then the whole thing turns into creditor voluntary winding up. Then what needs to be done? The company arrange a meeting of creditors immediately. Because the company is insolvent. The company is insolvent. It means the company cannot settle all the debt. So the creditors, they have the right to control everything. 即係你欠咗佢哋 right? You own them. Of course, you also need to notify the shareholders. Both the creditors and shareholders can nominate liquidator. But who is in control? Of course, creditor. Because the company is insolvent. So So how to control the whole winding up process? Just one thing, when you can appoint liquidator, when you can remove liquidator, then you are the one to control the winding up process. So in the compulsory winding up, who appoint liquidator? In the compulsory winding up, the court appoint liquidator. The court remove liquidator. So who is in control of the whole winding up process? The court. In the voluntary winding up, members voluntary winding up, who appoint liquidator? Members. Who remove liquidator? Members. So who is in control? Members. In the creditors voluntary winding up, who appoint liquidator? Look at here. Creditors. Right? Who can remove creditors? So who control creditors? So try to understand the logic. Very important. If you understand logic, you don't have to memorize everything, right? Because studying law is not about memorizing, all this stuff into your head. No, right? That's primary school. Right? You have to memorize something, of course, right? Memory is important, but not just, trying to memorize everything. That's not possible. But if you understand the logic, you understand everything. You need to take a look, right? At the lecture notes or the textbook, and then you understand the whole thing, right? But the logic, you have to understand the logic. And then the process will be similar. No matter there's a creditor voluntary winding up or a members voluntary winding up or even compulsory winding up, they are actually doing the same thing. And there's the liquidator to handle all the claims and to distribute all the assets in order to finally kill the company, right? Then how about directors? How the directors wipe the company? So this is a very special procedure, not for the members, but directors. Little bit different, right? So there are two things need to be done by the directors in order to wipe the company. Number one, they have to pass a resolution. Remember, they are resolution, not ordinary resolution, not special resolution, but just show of hand, right? Raising hand. 舉手, right? You raise your hand. Yes or no. More hands saying yes, that's yes. So they pass a resolution. It means they make decisions. Number one, the company cannot continue to operate because of the liability. That's very important. For members who are winding up, you remember that the first one is to pass a special resolution. When you can pass a special resolution, you don't need to have any reason at all. I just want to wipe the company. I don't need to have any reason. Even the company is making profit, I can still wipe the company. But for a director, right, think about that. The authority being restricted. Because the law states that when you want to initiate winding up by Section 228, the first condition is when the company cannot continue to operate because of liability. Right? The company is not capable to operate because of liability, because the company is running out of cash. There's a cash flow problem. You understand that concept. You understand that concept. You have an accounting background, or you have a business degree. You understand what I mean. When you make a profit, it doesn't mean that you get a cash, right? Or when you are making a loss, it doesn't mean that you are losing the cash. Because that's only an accounting concept. But cash is real. When you are not having enough cash to pay the rent, to pay the salary, right? Pay all the fees, then your company cannot survive. Right? That's a real thing. When your company is making a loss, you can still survive. Right? If you have cash, but if you are out of cash, you cannot survive. So it means that when the company is out of cash, it's not capable to survive, then you can initiate Section 228. It means the reason being restricted. You are not doing it of your free will, right? 唔係乜嘢做得. Only when the company is not capable to survive. Number two, the company can only commence winding up under Section 228. It means that I tried other means to wind the company. For example, you ask the members to initiate winding up by members voluntary winding up. You ask the members to pass special resolution. Do you remember that? They can do so, right? When the members pass special resolution, they can initiate members voluntary winding up. You try to do it in another way, but you are still fail. The members not willing to wipe the company. then you fulfill the second condition. Number 3, well, that's only a promise. You promise that you are going to notify all the creditors, but that's only a procedure. I don't think that's very important. But number 1 and 2 will be very important. It means that, remember, unlike members, right? Unlike the members, when you pass special resolution, you can wipe the company at your own wish, right? 我中意啊，吹咩啦？ I want to wipe the company. I just like to do it, right? 中意做乜做乜，呢啲就係 power 啊嘛，係咪 ？I want to wipe the company. I don't need to offer any reason at all, but you are a director, and if you want to wipe the company, you need to do it under certain reasons only. And then the directors appoint a provisional liquidator, and then they file the statement of paying, sorry, not statement, the statement of winding up to the common register, right? But don't mix up this provisional liquidator to provisional liquidator under compulsory winding up. What I mean by provision, right? Because they have to name that person first in the form. Name that person in the form. But once the form filed in the common register, that person immediately turn into official liquidator. So that may only last for a few minutes or a few hours. But because that person not yet officially appointed, but only being named in the form, so we still call that person as provisional liquidator. But unlike provisional liquidation in the compulsory winding up, that may last for several years. This person only work as a provisional liquidator because of the procedure, right? Because of the procedure. And that provisional status may only be named a few minutes. Okay? So once, as the directors, when you finish everything, then you have to file the form. This one, right? This is the form. So again, that will not be extended. Don't worry. I just want you to take a look. So the directors, they have to file the form. And in the form, they have to confirm all the conditions being fulfilled. I mean, the condition here. Right? So in the form, you have to sign on it. I hereby confirm that I fulfill the condition in number 1 and 2 and 3, especially number 1 and 2. The company cannot operate because of liability. I cannot wipe the company by other means, except for today, because I already asked the members to wipe the company, but they refused it. And that's very important, right? Because I handle real cases when the directors actually not capable to fail 1 and 2, but they still try to file the form to wipe the company under Section 228, because they thought that that will be a shortcut to save the time and procedures for a members voluntary winding up, because they can make a decision on their own. Remember that under Section 228, you don't need to have involvement of the members. So they wrongly thought that it was a shortcut, right? But it turned out to be a very serious problem. Sometimes it may be criminal, because that may involve forgery. When you are making a false claim, that may be fraud and deception, or PIN, right? Fraud and deceptions, because you lie to the court, right? You lie to the common register, not the court, because you made a wrong statement. Think about that statement. When you file a statement, don't underestimate anything you write in the form. When you declare that I'm doing it for a certain purpose, and then you are doing it for some other purpose, then you commit a crime for forgery, right? 做假文件. So don't underestimate that you just write something incorrect in the form that may turn out to be a criminal issue, right? So you have to be very careful and don't underestimate the consequence. When you file the form, it's very simple, just a form, but you have to make sure that you really comply with number 1 and 2, right? You need to have evidence. You really seek for the agreement of the members. I really try to persuade the members. Do you think of winding up the company? If the company is not capable to operate, right? And they refused it, then that will be safe. You better keep your communications, right? If you email or what. or telephone conference or anything, right? You have to make sure that you really fulfill the requirements here, but not just casually fill in the form. That will be very serious consequence, right? So don't regret at the time when you are being arrested, right? It always happens because they don't know it. I always handle cases because people are being careless or they're ignorant in law. But remember, very important legal concept in the law. Ignorance to the law is no defense. Ignorance to the fact can be a defense. When you make a mistake as to the fact, that can be a defense, right? When you listen to the reply from the members, when you read the email, because of their poor drafting, because of their poor reply, wrong grammar, so you misunderstand their reply. That can be a defense because that's ignorance to the fact. But ignorance to the law is no defense. It means you cannot argue to the court that I don't know that's illegal. That's nonsense. Right? The court never accept that. Right? Because everyone can make an excuse. I don't know killing someone is illegal. Right? Because that is legal in my homeland, right? I live in a small island in Pacific. In my homeland, killing someone is fine, right? No. So that's not allowed, right? So you have to be careful. You're going to learn about later in criminal law, in other modules. So this is the form. Okay, the solution. So finally, something very similar to compulsory winding up, but similar to compulsory winding up when all the properties first to be disputed in settlement debt, similar. Right? No matter you are having compulsory winding up or voluntary winding up, the liquidator do the same thing, distribute all the assets and to settle all the things. Then the court, but one thing is different. When you are being appointed by the court as a liquidator and you want to release from it, then you need to have the approval from the court. But because in a voluntary winding up, you are being appointed by creditors or members. So when you want to release from your duty, you seek for their approval. Right? Same logic, very simple. If you can get the approval, then within 1 week, you notify the CR. Then the company will be dissolved 3 months later. Why 3 months later? Because there may be objection from other stakeholders or anyone, right? So that will be 3 months later. But for the court order, which is immediate, right? Because no one can object the court, right? If there's a court decision and that's final, I don't have to worry about objections from the complaints or what from the public, right? But voluntary winding up is internal matters. That's all being initiated by the members or directors. So that's subject to the objection of the outsider. So you have to wait for 3 months. Okay? So again, understand the logic here. I try to explain to you the logic of the law, not just memorize everything, right? If you don't understand, you don't, why 3 months? You just try to memorize, and you are not capable to memorize everything if you don't understand, all right? Okay, the last thing before we end the class. Just 2 pages. It'll take you 2 more minutes. The proof of debt and priority. So you have to understand that what I mean by winding up, liquidator to handle all the claims and then to distribute all the assets. Life will be very easy if the company is having enough money to settle all the cases. 當然冇問題，係咪? Fine. If I have enough cash to settle all your claims, there will never be any trouble at all. And everyone is happy. How much you want, Simon? 1 million. You get, how much you want? 2 million. I pay you. No problem. Everyone is happy, even in the writing process, right? So you buy the big share, all the sharks, right? Buy the big share. Everyone get a big bite, and everyone is happy. But the problem is, most of the time, we don't have enough cash to settle all the claims. If we don't have enough asset, not necessarily cash, right? Asset, right? Asset. Then we have to think about priority. But before you can claim for anything, apart from priority, we have to understand the concept that we call the proof of debt. Because all the debts and claims against companies must be admissible only subject to strict proof. Right? Because the liquidator, they have to check your claims. Because when a company is in trouble, everyone wants to make a bite. right, want to have something. As a liquidator, you have to take care of a company because you have the duty to take care of a company. You have to make sure that the claims they are genuine. Right? It means that's real. So they're subject to proof. So how to do it? You have to serve a 14 days notice based on what? The statement of affairs. Do you remember the statement of affairs? Right? So you get all the name of the creditors here. So you serve a notice. You have 14 days. The company owes you money, you have to notify me within 14 days. If you are initiating voluntary winding up because you are the internal of the member, so you know that, right? You know that. If you are the directors, you already have that statement. But anyway, no matter, regardless of the mode of winding up, you have to ask all the creditors to prove the claim by filing affirmations. 誓章, right? Affirmations. It means you make an offer on it. You have to certify that, that's true, right? But that's a legal document. If you claim for, a wrong sum of money, or you try to claim for a debt not really in existence, that will be considered as a forgery again, right? So sometimes, right? Some people being arrested during the winding up process, and people don't understand. Because the winding up process is only a civil action. So normally, the police will not be involved, right? Normally, no, this is only civil action, right? Only civil action, just a tenancy agreement. You cannot ask the police to kick out the tenant, right? They won't help because it's a civil. So normally, that's not a criminal case. But sometimes people misunderstood that, well, winding up can be criminal. You see that someone being arrested. No, normally, no one will be arrested. Why someone being arrested? Because they have a false claims, just like the creditors, right? Or some of the stakeholders, they try to create some document not actually existed. Or they even filed a form with the wrong reason, right? Do you remember the section 228, when the director wanted to wipe a company? They state the information here, but the information being incorrect, forgery. When you try to claim from the company, and actually you don't have such a claim, forgery. When you claim from the company, but with incorrect sum of money, forgery, right? The liquidator reported to the police and someone being arrested, right? So you understand what happened here. Winding up is a civil action. If everyone is doing it honestly, the police shall not be involved at all. But sometimes you understand the bad side of human nature. I understand that very well. I'm a lawyer. So I'm handling civil or criminal cases. I understand the dark side of human nature. Right? So bad things always happen. Okay, then one more thing. We have to understand the priority. Because as I told you already, when the company is not having enough cash or not having enough asset to settle the claim, then we have to determine priority. What I mean by priority? Who get it first? Right? Who get it first? So I list out the priority here. Number one, the cost of winding up, the remuneration of the liquidators. Well, that is, I have nothing to say, right? You think about that. Who has the right to claim from the company with the first priority to liquidator, right? Not creditor, liquidator, for his remuneration. Well, that's very sad, but we have to understand that someone needs to do the work, and that's not charitable, right? The accountant, the CPA, it's a very heavy duty. There are a lot of work you have to do. Then you have to get paid of it. So the liquidator, they can claim it first, right? And claim for remuneration. Because when we don't have liquidators, we cannot carry out the liquidation process at all. So number one. Number two, preferential debts. We have two different categories for preferential debts. Number one, everything related to the government. Tax, or all the registration fees, right? 冇交咩牌照費都係呢個. Anything only to the government. Type 1. Type 2, anything related to employment. Salary, MPF, severance payment, anything, right? Holidays, anything, right? Anything related to employment, that will be type 2. But type 1 and type 2 together will be regarded as preferential debt. And then foreign charge. I don't have to explain to you, you already learned about foreign charge. And then unsecured creditors, it means that you don't have any charge created. You just want to claim on it. For example, you just signed a contract. I deliver the goods to the company. I'm supposed to get a payment, but I have nothing, right? Then you are unsecured creditors. Do you remember California, that fitness center closed, a few years ago, and a lot of customers they pay in advance, right? They pay in advance for their memberships for 3 or 5 years, right? So all of them are unsecured creditors. They just have a claim on it, but they don't have any securities being created. And last one, shareholders. If you are lucky, if anything left, and if you are shareholders, depends on what kind of shareholders. Do you remember the parent shareholders, ordinary shareholders? If you're ordinary shareholders, if there are anything left after the whole process, right, then you can claim for the remaining. But I can guarantee to you that 99% you have nothing, right? Normally you have nothing. One more thing before we end the class. How about fixed charge? I highlight in red, and that's a very important concept here. A fixed charge need not prove its debt. So don't mix up first priority, right? Not even priority. But for a fixed charge, that thing already belongs to you. You don't have to prove in that line. You don't have to lie up here. If I create a fixed charge on this table, so this thing belongs to me, because I already created a fixed charge, that will be even better than the first priority. Because you are in the first priority, it doesn't mean that you can get your full payment. So don't mix up, right? If I want to claim for $1 million, then the company is not having enough money to pay me, right? Then I don't have it. Even I am the first priority claim, right? Even I'm having the first priority claim. But if you create a fixed charge, then I don't have to care about the remaining asset of the company because these things belong to me already, right? So fixed charge is offering very good protection, better than on the first line, right? On the first one to claim. Okay, and okay, that's all for this module, right? So happy to meet you guys and to be your teacher for the last 4 weeks only, for 4 weeks only. This is the last lecture in teaching, but that's not the last class because we are having a revision class later, 4 months later. So I will be back. I will be back. Okay, so thank you everyone, and see you again. Right? See you again. I hope that you enjoy the whole thing. Right? Okay, thank you.今日獻花，冇女同學出嚟錫我頭。Okay, see you later. Right? See you later. 大家顏石都話咁呢個先咧。你講。入紙嘅申請，入紙同你最後攞唔攞到冇關。你可以係最早嗰個人，或者你係入紙嗰個人，但你仍然要跟住拉自己排。好啦，如果你跟住大家係對嘅，咁如果入紙你入冇關係，咁點？到時跟住嗰個 candidate 會覺得邊樣係對個申請人最有利，佢哋用呢個。即係嗰個冇一定，佢只會 rank 咗咁樣。但係中間嘅資源佢會點樣做咧？係個呢個都係仲有咁邊個咁搶得嚟？邊個咁出嚟？你同我都通常佢爭你最多嗰個你咪攞。咁但係我自己都排一齊做嘅，我多你又我可能都排。係啊，我都係有時可能都要喐㗎。有時要啱。我另外想問嘅話咧，之前成立公司我一個人可以嘅，一個人做呢啲即係嗰啲股市嘛。一個人大概可以做，大家睇啦，當然可以做啦，就 shareholder。但係個 company 石嗰度咧，佢可以同我一做晒。如果佢係得一個 direct。